Thank you, Mr. Takano. Mr. Smucker, you're recognized for 5 minutes.
Thank you, Madam Chairwoman. I'll direct this question to Mr. Reese and Ms. Thompson. Strengthening career and technical education, expanding apprenticeship opportunities, as you've heard, are top priorities of the committee and top priorities of mine. I believe it's critical to help fill the skills gap that we're currently facing in our nation. As you know, the President recently proposed an initiative to build up more apprenticeships in the private sector. And you mentioned that some of your franchisees and franchises are already doing some of this, and that employees can participate in apprenticeship-like opportunities in your companies. Can you elaborate on these opportunities and explain how the joint employer definition has prevented or interrupted your ability to continue offering these types of programs to employees?
Thank you, Congressman Smucker. We are in the trades, and apprenticeship programs are critically important because right now the trades are at an all-time low for people who can do the work. The millennials don't know how to do the work, and the millennials' parents don't want to do the work. And so we are having to home grow our, help our franchisees home grow those technicians and home service providers. And so we have a number of programs. I mentioned earlier Rainbow International, which is our restoration brand, has a good program where they not only train how to do the type of restoration work, but they provide certifications that give those apprentices an opportunity to grow within their field. And what's happening now is we're spending a lot of time and money reconsidering those programs because of the uncertainty of what's come from Browning-Ferris. It's causing us a lot of consternation and more time than it should be, and it's keeping us from growing our business.
Thank you. Mr. Reese?
We don't have any apprenticeship programs at this time. We're implementing programs with high schools in our area. The summer before college, right after high school, we want to hire in a couple of seniors so that they can go to college with some money in their pocket that they may not otherwise get, and teach them about franchising as well. But we have kind of pressed the pause button on putting that program into place, and I think the joint employer standard is one of the main reasons why.
Thank you. I'm going to jump back. I was a business owner as well, and it was a contracting company. We were a wall and ceiling company where we both contracted with a general contractor, but then we also would contract with other individuals who provided services to us as well. So maybe, Mr. King, this may be a question for you. I really have some concerns with the Fourth Circuit Court of Appeals decision that would expand joint employer beyond the Browning-Ferris case. We know it applies only there at this point, but do you think other courts are likely to adopt the same position? And if so, how will these standards further implicate companies that are already making tough decisions and changing their business models under the stress of joint employer?
Thank you, Congressman. First, this is a Fair Labor Standards Act case, so it does start to change the law if it holds. Second, certainly the district courts within the Fourth Circuit will be bound to follow this decision unless or until the Supreme Court accepts this case for review and overturns it. Beyond that, this plants the seed again for additional litigation. If I'm a plaintiff's attorney, I read the Fourth Circuit decision, I have a new theory to take to the Ninth Circuit, the Eighth Circuit, or the Sixth Circuit. What, again, the opponents of our position are missing is the litigation is evolving here to a higher degree than it's been in the past. So why can't we stop that and bring some clarity? So your question's an excellent one. The Fourth Circuit decision is going to create more problems for small and large employers and going to cost us more money in defense costs and have more litigation expense to deal with.
Do we have data on the economic and employee impact if that decision were expanded?
I've not seen any yet, Congressman, but that's being worked on because, as I mentioned, there are petitions for certiorari that were just filed. And if the court accepts this case, there's going to be a lot of documentation, a lot of research done to support the position that the Fourth Circuit simply is not in touch with reality. As I mentioned a moment ago, this new Fourth Circuit decision holds that if an employer just plays a role in setting the terms and conditions of employment. It can be a joint employer. What does that mean?
Thank you, and I'm almost out of time, but as that moves along, if there is additional information that becomes available in terms of the impact, I'm certain the committee would certainly love to have that information.
Thank you, Congressman. We will do that. In fact, we have filed today with the committee the amicus brief that the HR Policy Association, the U.S. Chamber, the National Association of Manufacturers, American Retail Federation, and RELA all filed with the Supreme Court. So we will certainly keep the committee abreast of what we are doing.
Thank you.
Thank you both very much. Mr. Rooney, you're recognized.